Hello, everybody. I'm Ben Holt. I'm currently the president of Bristol Law Society. It's great that so many of you could join us today. I'll introduce Seb formally in a second, but I just wanted to say a few housekeeping points. If you do have any questions during the webinar, please can I encourage you to put them in the Q&A box, which if you jab your screen or click your mouse, you should find, and Seb will hopefully pick those up at the end, time permitting. The webinar is being recorded and it'll be put up on the YouTube channel for Bristol Law Society later today. And we'll also be circulating a PDF version of the slides in the handout, together with a link for the recording from the event. I was at a conference yesterday and that was a 5-hour session, and I did find it quite helpful that it was recorded. Obviously this is live, but if you need to go back to the recording when you, if you're as bad as I am, drift off at any point and go, oh, that was an important point, you won't get the opportunity to ask Seb to repeat, because that'd just be embarrassing and it'd show that you've got a mind like a sieve like I have. But it will be there on YouTube, so you can go back and see that later. There'll also be a feedback form at the end, so if you could fill that in, it only takes a minute or so to fill in, that'd be fantastic. So without further ado, I'd like to introduce today's speaker. I'm going to be speaking about Brexit issues for litigators. So Seb Oram of 3PB, over to you. Thank you very much.
Thank you, Ben. I'm going to start with sharing my screen. Thank you first for inviting me. It's a pleasure to speak to Bristol Law Society. As Ben mentioned, I'm Seb Oram. I'm a commercial practitioner at 3PB Barristers. Part of my work is in commercial law, and the remainder is in construction law. The subject that I'm going to speak about today is civil litigation, the impact of Brexit. I'll start with a bit of a warning. It's a subject that's not for the faint-hearted, partly as a result of the process by which we've got to where we are. There are two features of that. The first is that we've sort of got used to having the law in one or two principal regulations, and that's no longer the position. The law is spread across a number of instruments. The second is the structure of analysing what the law is now sometimes requires us to have a knowledge of what the law was even before we acceded to the EU. So it does require casting one's mind back, or probably even just learning new law. And as a result of those two things, the process of identifying what the law is requires an exercise which is something between challenge Annika and time team. I'm going to steer a course during the course of this talk of not descending into too much detail, but equally identifying what the law is so that you know where to find it. Because of that, I've got a handout that goes into rather more detail of the points I'm going to be discussing, and includes links to some of the areas that I'm going to be taking you through. Let's start then with just an analysis of how we've got to where we are, because the chronology is probably important to understanding the sources of the law that now are in place. On the 31st of January last year, 2020, the UK left the EU, and it did so on the terms of the withdrawal agreement. For the next 12 months, there was a transition period, and that was governed by the terms of withdrawal agreement. And that came to an end at 11 PM on the 31st of December 2020. And so we're now in the position where we are well and truly out, even outside of the transition period. On 31st of December 2020, the EU and the UK agreed a future relationship agreement, which is called the Trade and Cooperation Agreement. And that's the time chronology of where we are now. The terms of our departure in terms of Acts of Parliament are contained in three sources. There's the European Union Withdrawal Act 2018. There's then the European Withdrawal Agreement Act 2020, which amends the 2018 Act to give effect to the withdrawal agreement. And then there's the European Union Future Relationship Act 2020, which implements sector-specific rules under the Future Relationship Agreement. The effect of principally the 2018 Act, which is going to be the focus of my talk, is that it unravels quite a lot of the law as it is applied to the resolution of conflicts of laws. This is the agenda then I'm going to take you through. In part one, we're going to look at the 2018 Act and how it operates, and look at the structure of it and what it does. Then we'll look at the ongoing status of retained EU law, and that's of general application beyond simply the question of civil litigation, but an understanding of what the Act does in that respect, in other words, what law it keeps, is important to then go on to understand how that's changed in the particular context of, in this case, civil litigation. Part 3 then looks at the impact of civil litigation. It's worth bearing in mind that when you're looking at these issues, there are 2 aspects that one needs to look at conflicts of law problems. The first is the law that the UK is going to be applying. The second part, which is equally important, is particularly when one's looking at, for example, the recognition of judgments and how they're going to be enforced in the EU, is what law will the member states be applying. I'll try and do both, although inevitably this is a talk about English law and English procedure. The structure of the 2018 Act, it does effectively 4 things. The first mechanism is to repeal the European Communities Act. The second is to take retained EU law, and I'll come on to describe what that is, and transplant it all into domestic law. It does that in sections 2 to 4, and then sections 5 and 6 explain how one interprets the law that's been retained. The third thing that it does is make a rulemaking power for ministers to change that law that's been incorporated. And so the purpose of those regulations is to deal with deficiencies arising from withdrawal, but it means that immediately one starts from a changed version of retained law, and one needs to see what those changes are. Finally, there's a rulemaking power in order to implement the withdrawal agreement. Now that's principally related to the transition period, which we're now out of, as I said at the beginning, but the transitional provisions will continue to have some impact, because in part it depends on the commencement of proceedings during the transitional period. I'll come back to that in a moment. Just before I move on to look at those elements in a bit more detail, it's worth just mentioning the repeal of the European Communities Act 1972. That was an act that acted as a conduit pipe that implemented EU law at a domestic level and also gave it precedence. It's what gave legitimacy and effect to European law consistent with the notion of parliamentary sovereignty in this country. Once it was repealed, it was necessary to determine and to make provision for what was going to happen to the existing body of law that we had been using over a period of 40 years. And so that's why parts 2, 3, and 4 of the scheme of the Act have been implemented. The first issue for us to consider is, where is the new law coming from? There are principally 3 sources of it. There is retained EU law. As I say, that's a concept I'll come on to have a look at in a little more detail. There's then the amendments that are made to that immediately under the Section 8 statutory regulations. And then there's finally specific provisions that are made under the withdrawal agreement and the future trade agreement. For the moment, we can park the future trade agreement. It contains nothing of relevance to conflict of law issues. And so we're really only looking at the retained EU law, the regulations that have been made under domestic UK law to change those, and then some specific provisions in the withdrawal agreement. Issue 2 is, as between those areas of law, what's the hierarchy? And that becomes relevant because, as I say, although the transition period has now ended, the Act gives priority to the provisions under the withdrawal agreement. So Section 7A of the 2018 Act says that first, domestic force is given directly to the provisions of the withdrawal agreement, but also insofar as there is a conflict, precedence is given to the provisions of the withdrawal agreement. So I've mentioned already that what's transposed is a concept called retained EU law. It's important to recognise that that is a snapshot of EU law as it stood on a particular date. The Act uses the term IP completion date. That's the implementation period completion date, i.e. 31st of December last year. The purpose of that is only to retain the existing law rather than being bound by the ongoing decisions of the European Court of Justice. Let's look then at what retained EU law is. This is defined under under the 2018 Act in sections 2 to 4. It consists of 4 parts. The first is domestic legislation, which gives effect to EU rules. So let's take, for example, the Health and Safety at Work Act 1974, which implements health and safety directives. It then has the direct EU legislation, and we're considering here provisions of EU law that don't need domestic law to implement them, principally regulations. So under that topic would ordinarily have included the Brussels recast regulation in respect of jurisdiction, Rome I and Rome II regulations dealing with conflicts of laws, and various procedural regulations that would have governed civil litigation. As you'll see later on, actually that hasn't happened because the UK decided not to apply a few of those. The third part of retained EU law are directly effective rights. I've set out in the handout in more detail what they are in order to provide a recap of how directives might have direct effect in UK law. But let's just, for the moment, describe those as directly effective rights. And fourthly, retained case law and general principles of EU law. A couple of observations. In respect of domestic legislation, that is defined quite widely. It doesn't include simply acts that are only implementing EU law. It can also include domestic legislation which relates to the implementation of EU law. So let's take, for example, something like the Companies Act, which in parts deals with the implementation of EU directives, but also goes above and beyond what the directives required. Insofar as it's relevant, EU law and case law can continue to be used as an aid to interpretation in respect of even those parts that went over and above what the directives required. It's uncontroversial that domestic legislation should continue to be enforced. Case law, we'll bear in mind again that we're looking at case law that existed at a particular point in time. It's retained case law, that's to say decisions as at the 31st of December 2020. And as I say, the purpose of that was, in order to preserve UK sovereignty, it was thought that the UK court shouldn't be bound by future decisions of the Court of Justice. Next question is, why is retained law relevant? And the answer to that is it will form part of or be recognised in UK law unless it is modified expressly by regulations made under Section 8. The existing law would be interpreted by existing case law, and that case law can be either domestic case law or European case law. And that's achieved by 2 provisions. The first provision is Section 6.3, which says that any question as to the validity, meaning, or effect of any retained EU law, insofar as it is unmodified, is to be decided in accordance with retained case law. The second provision deals with EU law supremacy, and that's Section 5.2. It says that the principle of supremacy continues to apply after the 31st of December 2020, so far as it relates to the interpretation, disapplication, or quashing of existing enactments before 31st of December 2020. So the idea is that existing law is used to determine and interpret existing statutes and enactments, much as the position was before we left the EU. There is a qualification to that. The senior courts of the UK are not bound to follow existing EU law. So Section 6.4 says that the Court of Appeal and the Supreme Court can decide not to follow existing EU laws and domestic cases, but can depart from them in circumstances where they might depart from a decision of the same court. So in terms of the Supreme Court, it would have to follow the 1966 practice direction to determine whether or not to follow or depart from an existing case of the Court of Justice. The second situation we need to consider is what happens if the retained law is modified. That's to say that we transposed European law. The UK decided to change parts of it by a statutory instrument. To what extent can the court look at existing retained case law to interpret that modified law? The answer to that is the court has to look at the purpose of the modification under English law and decide to what extent the retained EU case law is consistent with the intention of the modification. If it is consistent, then the court can continue to apply and interpret the law, notwithstanding that it's been modified. The third area is what happens in respect of future decisions of the Court of Justice. And the position there is that the UK courts are not bound to follow it, but there's a statutory direction to have regard to it where it's relevant. How will the courts apply that direction? Well, it's worth saying at the start that it is an entirely unfocused discretion in the statute. We're used to a canon of construction that says if there is a treaty obligation to give effect, if there is a treaty obligation, then domestic law will be interpreted in such a way as to give effect to that. This discretion is quite different because there is no longer any treaty obligation to give effect to it. And so the usual canon of interpretation wouldn't apply. I suspect that the answer is that the way in which the courts will look at this power to have regard to cases in the future by the Court of Justice of the European Community will be similar to the way in which it applies, for example, Commonwealth cases or US cases. If they're relevant, it'll continue to apply it. If they're not, it probably won't. And we can make two cautious suggestions. The first is that future cases of the Court of Justice can't be used to create a new right that didn't exist already. That's expressly provided for by the Act. The second is that the most likely situation in which this is going to be relevant is in circumstances where the UK has decided not to modify the existing law. The reason I say that is because there's a particular direction that's given in the Act for circumstances where the law has been modified by UK regulations. If we're only dealing with the same law existing in the UK and the EU, one would have thought that it would treat cases of the Court of Justice as being persuasive. In other words, follow them for consistency, unless there's a reason not to. That was a summary of how the Act works and the general approach to retained law and the interpretation of changes in the law. I want to move on now to the question of civil litigation and how that's going to change. There are 5 subject areas that I'm going to consider in turn. The first is the rules on establishing jurisdiction. The second is the rules on governing law. In other words, how does one determine which system of law applies to regulate the meaning of the dispute? The third is the process of service out to member state countries. The fourth is recognition and enforcement of judgments, and one needs to look at that in both ways. In other words, judgments of the EU coming to the UK and being enforced here, and the converse, a judgment of the UK being enforced and recognised in the member states. And finally, a miscellany of procedural questions on which there were previously regulations. By way of introduction, there was quite a lot of involvement in EU law that governed the jurisdiction and procedural rules that govern civil litigation in this country. Quite a lot of those have now been disapplied, but there's a key distinction between the systems that were based because they required reciprocity. In other words, both our system and the EU needed to be working on the same rules in order for the system to operate, and those which didn't. And so the explanation for those parts which the UK has decided not to keep is usually that those laws that haven't been kept required reciprocity from the EU side in order to work. And the result of those rules being displaced is that we now fall back rather on international conventions. Let's look first then at establishing jurisdiction in the UK. The issue here, let's take an example. There's a dispute between a UK buyer and a French seller. Both issue claims in their own courts. From one point of view, we're asking when will the UK courts accept jurisdiction in that dispute? From the other point of view, we're looking at what will the member state do if a related action is brought? So how are those conflicts resolved? Up until now, those disputes would have been determined by the recast Brussels regulations in respect of member states, and in respect of some of the EFTA countries, Norway, Iceland and Switzerland, that would have been determined under the 2007 Lugano Conventions. The changes that brought into force, first of all, the Brussels and Lugano Conventions are revoked. Nothing replaces them, so one falls back on the common law rules under CPR Practice Direction 6B. So the same position applies as it would to service out into any other country outside of the EU. And there are particular rules for consumer and employment contracts and for disputes arising under exclusive choice of court agreements. So where the parties have agreed that there will be exclusive jurisdiction conferred to determine that dispute on the courts of a particular country. The particular rules for consumer and employment contracts are now contained in sections 15B to 15E of the Civil Jurisdiction and Judgments Act 1982. Those changes are subject to transitional provisions held under the withdrawal agreement. And so, for example, those are going to be relevant where proceedings have already been started before the 31st of December 2020 in terms of considering how the EU courts are to decide disputes while those proceedings are continuing if related claims are brought in the EU member states. So there will be some continued, albeit probably not very long period, during which the transitional provisions under the withdrawal agreement will continue to be relevant. The reason for withdrawing the Brussels and Lugano regulations is that they depended on reciprocity. So, for example, Articles 28 and 27 of the regulation required a court that was first seized to examine its own jurisdiction and in circumstances to decline it if it didn't have jurisdiction under the regulations. Similarly, where there were related actions, Articles 29 and 30 required one of the courts seized to stay or to decline jurisdiction, while the second court was considering whether or not it had jurisdiction. And that system depended on the reciprocity between the two courts. In other words, they're applying the same rules to determine who has jurisdiction. If we couldn't be confident that the EU is going to be applying the same rules towards our court, the system broke down. And so that's effectively why those regulations had to be replaced. It's worth mentioning at this stage the 2005 Hague Convention. That's a convention on exclusive jurisdiction clauses. The problem with what's replaced the Brussels and Lugano Convention is that if you don't fall within an area of exclusive jurisdiction, and we're simply going under the gateways and CPR part Practice Direction 6B, the common law rules require a discretion. The Hague Convention would bring in a similar scheme to what existed previously. That's to say, a mandatory obligation of the EU states to cede to UK court jurisdiction questions and vice versa, but it was more limited. It was limited in a number of respects. The first is it only applies to exclusive choice of court agreements. In other words, there has to have been an agreement between the parties that the courts of a particular country of a contracting state are to have jurisdiction to determine the dispute, and it must be an exclusive choice of court agreement. They can't say that the court of one state and another. It has to be of only one contracting state. The second limitation is that there are certain subject matter exclusions to what can fall within the convention. So consumer contracts, insolvency, contracts of carriage of passengers and goods, for example, all fall outside its scope. Similarly, the UK has decided not to apply it to certain insurance contracts. So there are some areas in which the 2005 convention simply couldn't apply because of the subject matter of the dispute. The third limitation is the system under the convention only works if both states are signatories to the convention. The benefits, however, of the scheme is that it sets up a scheme of reciprocal duties similar to one that existed previously. Moreover, if a court accepts jurisdiction under the convention, and a judgment is produced, there's also then a system of recognition and enforcement, which the registering state, that's the state in which it's tried to be enforced, has to accept the judgment subject to very limited exceptions. So that's a new provision that's been brought in since we've left the EU. One practical problem that arises under it is that the convention only applies to agreements concluded after the entry into force of the convention in the state of the chosen court. So pausing there for a moment, assume that the parties have agreed to confer exclusive jurisdiction on the courts of England. That contract has to be entered into after we've acceded to the convention, and there's a dispute between the UK and the EU as to when that date is. The EU is adopting the stance that occurs on the 1st of January 2021, when we acceded in our own right. The UK, on the other hand, is saying, well, it actually takes effect from October 2015, when we acceded as a member of the EU to the convention. There is, it seems to me, a way that can be avoided. First of all, for future contracts, the problem will become less significant. If you're in a position where you have a client to whom it's critical that there should be enforcement of judgments in the EU, then bear in mind that what has to have postdated the entry into force of the convention is the contract on the choice of court. That can be separate from the contract of the underlying substantive dispute. So if you have an existing contract that entered into in 2019, let's say, the parties enter into a choice of court agreement to govern that existing contract. It would now, because the contract's entered into after even the January 2021, that would be an agreement that falls within the scope of the 2005 convention. That would mean that if you get a judgment in this country, it can then be enforced with rather less difficulty in the EU. Oh, sorry, I've jumped through a few slides. So the consequences of those changes in the rules, let's just focus on a couple of those. The first is that whereas the previous regime under the Brussels recast was based on the defendant's domicile, the focus is now on a rather more broad connection with the UK. That's point one. The second point is, to establish jurisdiction at common law, one has to get through one of the grounds in Practice Direction 6b. But those are only gateways, and even once you've done that, the claimant needs to establish that the UK is clearly or distinctly the appropriate forum for the trial of the dispute. Even when you get over that threshold, there is a discretion for the UK court to decide that it is not an appropriate forum. So what was a fairly clear-cut system now in theory becomes rather more subject to a discretion and the court being willing to accept jurisdiction. As I say, there are special rules for consumer employment contracts. The CPR 6.33 has been amended to provide that there doesn't need to be permission to serve out in respect of disputes that fall between those. And equally, there's a distinct regime for exclusive choice of law agreements under the 2005 convention. As I'll come on to, there's also permission to serve out where we fall within those without permission. In the longer term, the UK has applied to join the Lugano Convention. It made its application in April 2020, but that application depends on the consent of the other signatories, which include the EU. They haven't granted it yet. It normally takes a year, but there's no sign of it happening imminently. If in due course we become a member of Lugano, then we become subject to a similar scheme to what existed previously. And that would be of benefit because both in terms of jurisdiction and in recognition and enforcement of judgments, there'd be a rather more clear-cut system based on reciprocity, where we could be confident both that the EU would decline jurisdiction in circumstances where we would accept it, and that they would also enforce our judgments. Still continuing on jurisdiction, let's look at what are the circumstances in which jurisdiction might be challenged in the EU. The effect of us leaving the EU is that for the purposes of recast Brussels regulation, the UK becomes a third country. So when there's a dispute or a conflict between related actions, different rules apply under that regulation. Effectively, what they mean is that the EU's decision whether or not to accept jurisdiction or to decline it in a related action becomes discretionary and becomes based on a test of necessity. Prior to that, it would have been obliged to decline jurisdiction in rather wider circumstances. On the other hand, there are some supposed benefits from the recast Brussels regulation not applying. One of those, for example, is that a party might be able to now obtain an anti-suit injunction to restrain proceedings in the UK courts. So that would overturn the decisions of the European Court of Justice in Turner and Grovitt, which decided that wasn't possible under the mandatory system of the Brussels recast regulations. Similarly, the controversial decision in Owusu and Jackson, which held that a court subject to the regulation cannot decline jurisdiction on forum non-conveniens grounds where the regulation applies, might now no longer be followed. In other words, the court in the UK can decide whether or not to accept jurisdiction on the basis of the convenience of the forum. Let's look then at the next area. We've covered jurisdiction and we're now moving on to the applicable law. The situation here is how does one regulate which system of law applies to the substantive dispute. There's less change in this area. Up until now, the situation was that for contractual claims, the question of which law applied was the Rome I regulation. For non-contractual claims, it was Rome II that applied. And the position now is that those have simply been translated under the 2018 Act into domestic law. There are some very minor modifications, but essentially it's to remove the references to the UK being a member state and now refer to relevant states. But otherwise, the way in which conflicts of law are resolved as to the governing law are pretty much the same. That was all possible because neither of those regulations depended on reciprocity. So under either of those regulations, the relevant system of law didn't need to be the system of a member state. In other words, if the parties agreed, for example, to apply the law of the United States, the conventions, the regulations would apply that system that had been chosen, even if it wasn't one of the member states. That means that we can be confident that the EU courts will continue to give effect to the governing law clauses. The next area I'm going to look at is affecting service in the EU. We're looking at two issues here. The first is, in what circumstances do we need to obtain permission to serve out to the EU? The second issue is, what are the mechanics and procedures that one uses to effect service in the EU? Up until now, CPR 6.33 was drafted so that if you fell within an area of jurisdiction under the Brussels regulation or Lugano, you didn't need permission to serve out. You could simply serve under the regulation. In respect to the procedure for service, up until now, there's been the EU service regulation and an EU regulation that permitted taking of evidence in commercial matters. Those have changed. CPR has been redrafted. You do not need permission if you're bringing a claim of a consumer and employment contract that falls under the Civil Jurisdiction and Judgments Act 1982 as amended. You don't need permission if you can bring a claim under the 2005 Hague Convention on choice of court agreements. There's also going to be an imminent change to the CPR to permit service out without permission under any choice of law agreement that points to the UK. So even if you're under a choice of law agreement that isn't exclusive, so it doesn't fall within the convention, you shouldn't need permission in due course in order to serve out and give effect to that agreement. The EU service regulation and the EU taking evidence regulations are both revoked. And the effect of that is that one, in order to determine the procedures for service, need to rely on international conventions. The most obvious one is the Hague Service Convention. It's not a new convention and it's been applied to most of our trading partners outside the EU up until now. So it's a familiar system that has been in use for a while. It operates on the basis of a similar system of central authorities in each state. In the UK, the central authority is the Queen's Bench Foreign Process Section. And there is an alternative system of service under the Hague Convention, but it depends on any particular contracting state not having objected to it. The alternative systems are either by post or through consular means. In the handout that I've circulated, or will circulate after this talk, there is a link to the Hague website, and once you've got used to, once you've got the hang of where to look, it's relatively easy to see which state allows service by those methods, so that you can decide whether or not it's necessary to go through the central service. We come next to recognition and enforcement of judgments, and at the moment I'm looking at UK judgments being registered in the EU. Until now, this has been again dealt with by the Brussels recast regulation and Lugano. As I've already described, both of those have been revoked, but it's subject to transitional provisions under withdrawal agreement. So Article 67 of the withdrawal agreement provides that in respect of proceedings that were commenced during the transition period up until the 31st of December 2020, a judgment that is produced in those proceedings is still covered by the previous regime. That'll be of relevance for a little while still. The consequences of those revocations is that if you can fall within the 2005 Hague Convention, then you can bring yourself within the bespoke scheme for reciprocity of judgments that's provided by that convention. That's important for outbound UK judgments, because essentially there's a very limited scope for refusal of recognition by the other contracting state. That involves generally no review of the merits of the decision. And insofar as one is assessing whether or not the grounds of refusal are made out, the registering court, that's the one in which the judgment is sought to be enforced, is bound by the findings of fact made by the court in which the judgment was made. If you can't fall within the 2005 Hague Convention, one otherwise has to look to bilateral agreements with individual states. For a number of the member states, Austria, Belgium, France, Germany, Italy, Norway, and the Netherlands, there are such bilateral treaties in force. For those countries, the recognition and enforcement of judgments takes place under a 1933 Act called the Foreign Judgments Reciprocal Enforcement Act. If you're trying to enforce in a different state, that's one with which we don't have a bilateral agreement and you can't fall within the Hague Convention, then each country determines its own domestic rules for whether or not it's going to recognise. That works similarly from the UK's point of view. If you're trying to enforce from the EU into the UK, the procedure is governed by common law, in effect an action under the award, in which the court looks at whether or not the referring court had jurisdiction. If so, it would give effect to it by an English judgment. It's worth bearing in mind the complications of that system. It's worth bearing in mind that arbitration is a system that's governed under the New York Convention. There are a far larger number of countries that are signed up to that, and it might become a more useful means of enforcement in the short term where it's available. As I said earlier, the Lugano Convention we've applied to join, but that's going to take a little while. A summary then, just what I've described before, first of all, in respect to the 2005 Hague Convention. Insofar as a judgment has been obtained in breach of an exclusive jurisdiction clause, the UK court wouldn't enforce an EU judgment. Conversely, a foreign judgment will be automatically recognised if it falls within the scope of the 2005 Convention. We've gone through then some of the areas of civil litigation. It is a meaty topic that covers quite a broad range of rules, both procedural and substantive. to the extent that we can draw conclusions, the process of identifying what the law is has become rather more complex. The rules for identifying the applicable law don't change, but what has changed significantly are the jurisdictional rules. For those, we either fall back on the common law provision and the gateways under Part 6B of the Civil Procedure Rules, or one tries to fit oneself within the Hague Convention or other conventions that allow reciprocity, but that's rather more limited. Similarly, in areas of service and procedure generally, one has to try and make use of the conventions, principally the various Hague conventions that exist. And that is a brief look through the changes to civil procedure. As I say, some of the detail of that is contained in the handout. If anyone does have questions, we'll have a look now and see if any have been asked. If you haven't asked a question, but you have one, do feel free to post it now.
Seb, I had a question. It's Ben here. So say, for instance, if a client had a judgment in, say, Germany, and I think the answer to this is it's not entirely straightforward, but if they had a judgment in, say, Germany now, how easy is it to go about? Well, obviously, previously it was relatively easy to enforce EU judgments here. What's the score now? Is it a right nuisance? Is it easy enough to sort out?
The starting point is, can you bring yourself within the Hague Convention? If it's a contractual claim where you've got an exclusive choice of court agreement, then it's relatively simple. The judgment obtained in any of the EU member states, because the EU is a signatory to that convention, we would have to recognise and enforce it here subject to very limited grounds. They are lack of capacity, fraud, and so on. If you can't bring yourself within that, then I can't recall off my head if Germany is one of those with a bilateral treaty, but let's assume for the moment that it is not. If it isn't, then you have to bring an action on the judgment. And what the court in the UK would be looking at is essentially, did the foreign court have jurisdiction applying our jurisdictional rules? So it's not hard, but it is rather more convoluted. It's certainly not a paper-based decision, which is what used to be the case under Brussels recast and Lugano.
Thanks for that. I mean, it might be a bit too involved a question for now, but what in terms of bringing within the Hague Convention, what sort of things does that typically look like?
The restrictions are, I mean, it covers most subject matters, subject to the exclusions of a list in Article 2 of the Convention. So insolvency, for example, wouldn't be covered by it. Some carriage of passengers and goods aren't covered by it, so certain subject matters are excluded. The key limitation is that the convention only applies if you have an exclusive choice of court agreement. The second limitation is that agreement has to have been formed after we acceded to the convention. Now, the EU is adopting a stance that's in 2021, which means that if you're talking about a contract or a claim that's before 2021, you now have to ask your clients to enter into a separate choice of court agreement in order to fall within that system.
I can't see any further Q&As coming through, so we'll just give people 30 seconds in case they do have anything to add in there. I'll avoid talking about my lockdown hair again.
I will say that some of the footnotes in the handout do go through some of the points I've made in a bit more, not necessarily detail, well, they do go in more detail, but also they just identify where the law is. It's a process normally of just trying to identify where the rule is, but once you're there, it's reasonably clear. It's just the process of getting there that's a bit complicated.
Thank you. Well, if we don't seem to have any questions coming through, so unless you got anything else to add, I'll say thank you very much, Seb, for your time and the really helpful webinar. It does seem like a bit of a minefield, so I think I'll be keeping a copy of your notes close at hand for any responding to any client questions that might come through. And yeah, we also the comments are on the questionnaires about Q&As, but someone also looking forward to receiving the handout. I think that'll be very well used. I would probably suggest you stick your name and branding all over it, because people know that phoning you up to clarify on it. But thank you everyone for. Oh, more questions coming through. Is this questions or comments? Yeah, no, they're just comments. That's fine. So on that note, thanks everyone for attending. Good session. We'll be following up with the link to the video and the handouts afterwards. And do check the website, as I said, for upcoming webinar details, or you can email Bristol Law Society to find out more. Thank you, Seb, and thank you everyone for attending.
Thanks very much. Bye.